It is the judge's fault. Donald Trump is explaining why he didn't take the stand in his hush money/election interference trial in New York. Speaking to WABC Radio, he said he wanted to testify, but he decided not to because he didn't trust Judge Juan Merchan.
Because he made rulings that makes it very difficult to testify. Anything I did in the past, they can bring everything up. And you know what? I've had a great past, but anything. But the other thing is, and the main reason, and I don't even mind that. In fact, I like talking about it because we had rigged cases. New York is out of control. The other reason is because they have no case. In other words, why testify when they have no case?
Joining us now, NBC News legal correspondent Lisa Rubin. It's so funny. It's like you can follow his thinking there because he's saying I can't trust him. He's going to bring up past stuff, and then in real time he's thinking, wait, hold on. I can't admit that past stuff might be bad. I've had great stuff. Mm-hmm. So explain what he's talking about. This is the Sandoval hearing. I'm reminded again, it is not Scandoval. It's not about cheating on your longtime girlfriend with your mutual friend.
Even if you love Bravo, no, that's not what it's about. The Sandoval hearing is a New York State procedure that's designed to help a defendant make an educated decision about whether they want to testify by having the judge rule on the permissible limits of cross-examination. That hearing was held on April 22nd. The people, meaning the Manhattan DA's office, talked about a number of different legal judgments against Donald Trump that they would like to explore were Trump to take the stand. And the judge decided that a number of them were, in fact, things that they could explore. That includes the civil fraud finding that he violated New York state law by fraudulently misstating the value of his assets for an economic benefit. It includes both of the E. Jean Carroll verdicts, but solely on the defamation issue, not the sexual assault count, because that would be prejudicial given some of the issues in this case about hush money. They also found that they could bring up violations of the gag order regarding Judge Arthur Engoron and his law clerk. Not only that Trump failed to take down a post about the law clerk, but also that he continued to willfully and intentionally violate a court order by making public attacks on the law clerk, despite 2 prior court orders not to do so. And it goes on in terms of what the DA's office would be allowed to explore. That is what Trump is referring to. Now, it is not the case that they could have explored anything and everything in his past, as he said, but it's also not the case that that past is uniformly a good one, as illustrated by some of these judicial findings that the DA's office would have been allowed to bring up.
They could bring up everything from my great past. All right, let me ask you about the other hearing that we were following yesterday. This is the one down in South Florida with Judge Aileen Cannon regarding Nauta's motion to dismiss the case. It got tense in there, or at least it sounded like it got tense in there. What do we know that happened?
So one of the things that Nauta's lawyers want to do is dismiss the case on grounds of selective and vindictive prosecution against Nauta. One of their grounds for doing so is a meeting at which a Department of Justice lawyer reminded Nauta's lawyer that he had a pending application to become a judge in the District of Columbia, and then promptly followed that by a reference to having his client cooperate. The implication, according to Walt Nauta's lawyer, Stan Woodward, was that they were basically saying to him, if you don't turn over your client to cooperate, we'll make your judicial application go not in a way that you want it to. You don't seem particularly Trumpy to us. In fact, we know that you've applied for a judgeship. That judgeship, while it's a District of Columbia judgeship, is controlled by the president. It is a federal position. And so this lawyer, Stan Woodward, is saying these guys were trying to, basically retaliate against my client because I didn't want him to cooperate, and retaliate against me by saying that my application for a judgeship wouldn't be processed. Judge Aileen Cannon, when the Department of Justice's lawyer got up yesterday to argue this and was impassioned about this is not what happened at that meeting, told the lawyer David Harbaugh, you need to calm down. And Harbaugh was offended by that, at one point saying, according to the New York Times, it's just not right. In other words, he felt that the truth was really misrepresented, but Cannon telling him that he was just really getting too exercised for her.
I wonder if she does grant the motion to dismiss, whether that might be a blessing for the special counsel, because then they can appeal it.
Very much so.
Maybe. We'll see. What do I know? Lisa Rubin, that's why we have smart people like you here. Lisa Rubin, thank you very much for joining us, as always.